even giving, my lord, property, money, inheritance, etc. So there is no reason why, once our rights are identical and same as held by your lordships, my lord. And that has been the development, my lord, in the US and other nations. I have made a one-page chart which I'll show to your lordship. Therefore, my lord, we seek a declaration, because we have to be concrete. What do we want from the court? We seek a declaration that we have a right to, my lord, get married. Lord, will be recognized by the state. Other acts, but as far as I am concerned, my lord, my brief is to say that we want a declaration that we have a right to marriage, and that marriage will be recognized by the state by virtue of the imprimatur of this court. And once that happens, the society will recognize us. Because even after 377, my lord, there is a stigma. If two people walk hand in hand in a park, my lord, or in a hotel or in a mall, they are still stigmatized in public. That stigma will only go after the imprimatur of this court that they are entitled to get married, and the state shall recognize it. And once the state recognizes it, it can also be registered. And that will be full and final assimilation of this minuscule group, my lord, into
assuming that you seek a declaration from the court,
yes,
that queer people belonging to the queer community,
yes,
same-sex couples
have a right to
have a right to marry, and therefore the state must recognize the marriage between these two. Now, what is the next step? Are you therefore saying that the Special Marriage Act already recognizes that right inherent in it?
Well,
a matter of an interpretative device or an
by an interpretative, I don't want it to be quashed or anything.
Right.
By an interpretative device, in one line, if I was to say, the provisions, my lord, of the Special Marriage Act made in 1954. Today, my lord, we are now 70 years down. There is a lot of evolution. As I said, my lord, live-ins, etc. have now come in. I want to say, my lord, that your lordships will broadly read spouse in place of man and women, or husband and wife. And that is it. And if I may show, my lord, a classic example of the definition of marriage in Black's dictionary, which I will show to your lordship. In 1968, said, my lord, it's a union of a man and woman. But when the definition came in 2019, it says, my lord, a union of two persons.
Concept of marriage is changing.
So concept of marriage has changed over last 100, 200 years. We had concepts of, my lord, group marriages. We had very different concepts. We had concepts of child marriage. We had concepts of, my lord, temporary marriages. We had concept that, my lord, prior to the Hindu Code Bill introduced after by Pandit Nehru, my lord, in 1950, a person could marry any number of times. That, my lord, also changed. Hindu Code Bill, my lord, was not accepted. There are a lot of protests to this new avatar of the Hindu Marriage Act. It was not accepted. And Dr. Ambedkar had to resign. Then came the evolution of Hindu Marriage Act. Now in Hindu Marriage Act itself, my lord, in 2005, the rights which were restricted of women, starting from the Women's Right to Inheritance Property Act in 1937, all that has now changed, my lord. And full rights are available in 2005. So, my lord, Constitution is a living document. The preamble says, my lord, equality, fraternity. And I will read passages of, my lord, the Chief Justice, my lord, judgment, my lord, in Navtej, in Puttaswamy, in Shafin, in Deepika, and Justice Kaul, my lord, also referring to it. This is the thread. If this is the thread of the Constitution, equality, fraternity, justice to all, today we are a part of the all. The only thing which was stumbling, my lord, was that criminality. That is now gone if we are a part of all.
So really, your analysis is two-step. One, the declaration of marriage as a fundamental right as being implicit in the constitutional guarantees 14, 19 and 21.
No, as interpreted by lordships, my lord, in Puttaswamy, Navtej, basically.
And then step two, the second limb of your submission, that this also can find recognition by a reading, an appropriate reading of the Special Marriage Act.
My lord.
So you're not going into the broader issue of personal law and other things, we take it. Right?
No, my lord, I am not.
Right.
And I am not also touching any personal law of Muslims, etc., my lord. Somebody may raise an issue, I am not. Hindu Marriage Act, yes, but basic first will be Special Marriage Act. And your lordship knows, my lord, a legislative tool in the Indian legislative devices has always been that the definition clause always starts with, my lord, your lordships are aware, unless the context otherwise requires. That is the elasticity given to every legislation, more or less, in this country by Parliament, that you have to, my lord, adopt or adapt to 20, 30, 50, 70 years later. Can't keep changing the law, can't keep changing definitions. So you have, unless the context otherwise requires. So if the context requires that a man and a woman or a husband, wife to be treated as persons or spouses, your lordship will do it by an interpretative route, number one. Number two, this question, that whether, my lord, the court should wait for the legislature to act. Firstly, it arose, my lord, in Navtej. The court, my lord, entertained rather than waiting for the government to, my lord, remove it or not remove it. But there is, my lord, authority for the proposition in, my lord, Navtej, Chaira Banu, Puttu Swami, that the court need not wait for legislative, my lord, interference. And if it is brought to the court's notice that by fundamental right is being restricted, my lord, by the state or by this society because of its mindset, which has to now open up, the court's duty is to act. That is, my lord, clearly laid down. My lord, our lives are passing by. We are getting older. We also want to have the respectability of a marriage, respectability of a couple. What is the point of saying that only criminality in your bedroom is removed? But, my lord, when you go out, there is a passage of Justice Chandrachud, my lord, in one of those judgments, that what matters is what happens in a public space. What is the concrete position? If today, my lord, what is the position? All right, 377 is gone. But if these people, call them queer, call them strange, people call them all different names. If they were to go to different places, people look at them. Look, they are going this way, they are going that way, they are doing this, they are doing that. That, my lord, that is a restriction or an infringement of my right, which is Article 21, to, my lord, live with dignity, freedom, privacy, full expression of thought under 19(1)(a), no discrimination under 14, and, my lord, in 15, as your lordship knows, there will be no discrimination only on the ground of sex, caste, creed, etc. And only on the ground of sex, your lordship's judgment, Justice Chandrachud, talking about Nargesh Mirza, that Air India case, and, my lord, that Anuj Garg, that, my lord, the Delhi hotels case where, my lord, women could not, my lord, become employees. So your lordships have accepted Anuj Garg, which is an expensive definition of sex to mean sexual orientation. Sex does not mean, my lord, only male, female. And your lordships have, my lord, discounted the verdict in Nargesh, clearly. So Anuj Garg has been accepted by Lordship Justice Chandrachud in that judgment, and also, my lord, in Nalsa, where we're dealing with transgenders, there are passage after passage that if you have to give them equality, that equality, my lord, also must reflect positively. So you have the negative part, don't discriminate. There is a positive part in 14 and 15, affirmative action also. My lord, sorry to say that Nalsa said that give them reservation. Years ago, nothing is done. Years ago. Your lordship judgment, my lord, in Navtej, gave full publicity. Today I read in the Indian Express, today, your lordship judgment says give full publicity. People must know that it's not a criminal offense. Don't look at them with this stigma. My lord, years ago that judgment was delivered. Nothing done. And the three ministries today say, we have not done anything and we are not supposed to do anything. If this is the state of affairs of legislative, my lord, interference or legislative response to judgments of this court, I have no choice but to knock at the doors of this court and say, my lord, I have a sense of deja vu. I was here, I opened the case on 377 years ago, before 5 judges, 5 years ago, in this court too. This is how, my lord, we reach step 1. And there is a passage in Justice Chandrachud's, my lord, verdict, which I will show, my lord, that this was the first step. That is that sense. This was the first step. Remove that obstacle. Bring them up to the mark with the others. They will walk, my lord, shoulder to shoulder. The Constitution said secular. What is secular? Regardless of caste,
जो ये अपराधी हैं, जो ये
orientation, full expression. So we are a part of one homogeneous whole, but with dissimilarities of caste, creed, color, religion. But everybody is entitled in our secular polity, a pluralistic society. Justice Abarwal, my lord, in Coelho. Secularism is a part of basic structure. Equality is a part of basic structure. If they are a part of basic structure and a part of the triangle, my lord, I would say quadrangle, not triangle, 14, 15, 19 and 21. If they are a part of that which are inalienable, part of the basic structure, cannot be removed by anybody, cannot be tinkered by anybody, as understood by your lordships. I am not reinventing the wheel. Whatever I am saying, Lord, is actually a paraphrase of what I have read in the last couple of days from those judgments. And I will show you some passages. I am only going to put the pieces together, Lord. And I have, my lord, for a lordship's, my lord, convenience, Justice Bhatt might recall, my lord, in that reservation case, I had made a big chart to show you how the judgments went, my lord, in reservation. Here I have made, my lord, your lordships found it, my lord, useful. Here I have, just hold on, dude. I have made, my lord, a one-page chart. Starts, my lord, with, my lord, 1816, the penal code. Your lordship just have a quick glance. It will be easy. This will give your lordship, my lord, a very quick glance. Because I think only Justice Bhatt was there, my lord, in that case of the 5 judges here. Kindly, my lord, just see. Input my juniors, not by me. I only dictated, my lord, the flow. So, yes, so today is the rainbow, my lord. This is the rainbow. Kindly see, my lord, penal code by Macaulay. In fact, Justice Chandrachud has used, my lord, the full name of Macaulay, which I didn't, which said Babington. Yes. Then, my lord, these were laws introduced in different colonies under the British Empire. 47 is our constitution. 67, my lord, was the Sexual Offences Act enacted by Parliament, which legalized homosexuality in 67. Now, see, my lord, September 96, US is very, very, my lord, interesting. US federal government enacted DOMA, which stated that federal law shall not recognize the same-sex marriage. Because, my lord, pausing here for a minute, some states had started recognizing. So center came and said, we will not recognize because they have state and central lordship. So they formed, my lord, this DOMA that we want to keep away. Then, my lord, came Lawrence versus Texas. This was a case where there was a raid, my lord, in the house of Mr. Lawrence. And during the raid, he was found to be, my lord, committing an act which was held to be this unnatural act. And he was then charged. Object was raid, but they found him, my lord, in the bedroom, etc. So, in Lawrence, my lord, the Supreme Court upheld the right of Lawrence. It struck down, my lord, that Texas law, which was, my lord, akin to our 377. Then came Nas. Now see 2013. In Windsor, my lord, the Supreme Court struck down DOMA. That is, that federal law was struck down by the Supreme Court, my lord, by the US Supreme Court. Then came, my lord, Kaushal, which reversed, my lord, the Delhi High Court. Then 2013, the UK Parliament enacted another act to confer equal rights and protect dignity of same sex. 2014 is our NALSA. Now mark 15. In 15, my lord, in Obergefell, it recognized the rights of same sex, legalized the same in the country. My lord, your lordship may mark and I will show the definition of marriage in this judgment is classic. What is marriage? How, my lord, important it is. I'm going to show that. How important it is. And this happened, my lord, in 2015. And this is referred to, my lord, in Navtej and Shaira Banu both. Then, my lord, came Puttu Swami. I am not reading, my lord. But there are some passages, my lord, of His Lordship Justice Chandrachud, as His Lordship then was. And I have given those passages which I am going to read. And some passages of Justice Sanjay Kaul. Then, my lord, Shafeen Jahan and Shakti Vahini. Here also, my lord, if I may say so, the common thread is the Chief Justice. In regard to, my lord, the right to marry a person of your own choice. If you have a right to marry, my lord, a person of your own choice in the heterosexual group, and we are identical to them in terms of our right, it follows, it's QED, it follows that we should also get it. And therefore, you will have to, my lord, qualitatively interpret the laws which were framed in 54 to now fall in sync with what your lordships have said in the last 5 years. That is, my lord, Shafeen Jahan. Then came, my lord, section 373 of Johar. Then in 2022, US enacted Respect of Marriage Act for protecting validity of same-sex marriages. Currently, 31 countries recognize the same-sex, I've given the names. Then came Deepika Singh, Lordship, Lord the Chief Justice. Again, right to marry, familial relationships, or even queer relationships as they are called, is specifically, my lord, dealt with, and that it should be, my lord, can be a family unit, etc. Now, see, my lord, the last definition of marriage in 1968 in blacks. Marriage is distinguished from agreement to marry and from the acts of becoming married is a civil status condition relation of one man and woman united in life, in law for life for the discharge, the other and communities of duty legally incumbent or those whose association is founded definition of sex.
Union relies on. Now it's changed.
Now, my lord, your lordship may mark here, the union relies on the 1968 definition in the counter affidavit. A detailed counter has been filed by the union of 40 pages. So it's not correct to say that I have to now again look at, my lord, what the government will say. They have filed a big affidavit, very big affidavit. And they rely, my lord, on the 68 definition. But see, my lord, the definition of 2019, after, my lord, society has evolved. The legal union of a couple. The essentials of valid marriage are parties legally capable of marriage, mutual consent, any actual contract in the form of law. Definition, Lord, of same-sex 2019, ceremonial unit of two people of the same sex, whether man or woman. This is the evolution.
Is the union following this?
So, my lord, union, government of India is following blacks, but it is following an antiquated edition. If you are following the same, my lord, definition or the same dictionary, I say follow the latest version. You can't follow a version, my lord, which is 50 years old. So, ultimately, my lord, it is this, not the Chief Justice has put it. I want, my lord, I request, not want, I request. For example, my lord, the two petitioners in the first case, who are they? Two individuals who met, who had a bond of faith, love, partnership. They want to, my lord, reach the status of a married couple, like the other persons, and have a family. They cherish the same, my lord, what is cherished by the others. They want to lead a dignified life, what the others also lead, and not always to be looked upon. Look at them, look at them. For that, your lordships have removed the one block, that they can't go to jail. The second step has to be affirmative, which is a recognition of the right to marriage so that we are equal, recognized by the state, so that, my lord, society then follows the state. Because society, my lord, is resistant to change. Human beings are resistant to change. So society follows what the law is, and the law is what is, my lord, said in parliament or what is declared by this court. That is the law.
The only thing which we'll also need to apply mind to, if you look at your chart,
my lord,
if you see the US, September 96, the federal government enacts the Defense of Marriage Act,
yes,
which says that the federal law shall not recognize same-sex marriage. Then comes 2013, of course,
Windsor,
the UK.
Or
Windsor,
UK.
That's right.
Yes.
And then 2013 comes the act in the UK, conferring upon all same-sex.
Lord, Windsor is also there.
Yes.
Windsor, Lord, 2013.
Yes, that's right. Windsor.
When DOMA was struck down, the federal law was struck down.
And struck down DOMA.
My lord.
Right. Then comes in the UK, you have a legislation which recognizes same-sex relationship.
My lord.
And then finally in 2022, you have the US Respect for Marriage Act.
Yes.
2022.
Yes.
So you had in the US something which was debilitating, which was removed from the statute book. Then you have something positive which is enacted in the UK, and then which is enacted in the US as well, the 2022 legislation. Now, what we therefore have to really consider is exactly what the other side is urging.
Yes, I understand that the drift of the question. Anyway.
These essentially matters where even in the US and the UK, legislature has intervened earlier by outlawing and later on by recognizing. In the absence of legislation, How does the court go about it?
Yes, I understand the question.
Is there a contra? I mean, is there any indication in our legislation precluding the court?
So, my lord, yes.
Or is there a legislative space within which the court can then
I understood the question. My respectful submission, my lord. One, my lord, your lordship may see the judgment is over Jeffel in 2015.
What is the right of marriage and what is the constitutionality of an enforcement of right of marriage? Because what they are saying is you live together, you want to do whatever you want, but you can't tell that you want to perform whatever ceremony you want to do or whatever you call it as a marriage, but you can't give an imprimatur and say that that will be registered or recognized. Therefore, we'll have to go back to what is the enforceability of a right of marriage.
So, my lord, if I may answer first the Chief Justice. My lord, if your lordship says 2015, I have understood the drift, my lord, there the legislatures acted. They acted pursuant to the judgments or feelings of people, they acted. Here, but in 2015, my lord, as far as Ober Jeffel is concerned, it recognized the right of the same-sex marriage and legalized the same. That was a judicial imprimatur. It legalized.
Correct me if I'm wrong.
Sorry.
There were constitutions and there were laws which were amended or enacted which prohibited gay or same-sex marriages. Same-sex marriages. Obergefell actually struck down that and said,
right,
you have a right to marry. Now, the wheel has turned a full circle where you have a complete federal cover in the sense that you have a...
Yes, your lordship is right.
Right? So, we are at that stage.
Yes.
So,
yes, your lordship is right.
We are at that stage, so how do we go about this?
So, my lord...
One is the declaration part
which I am seeking. My lord, what I am respectfully submitting, answer to both of your lords, three of your lords. My lord, if, as distinct from UK and other places, if we have a fundamental right under 14, 19, 21, whatever, to be treated as identical and equal to our other brethren, then the full enjoyment of our rights to be equal to them includes the right of dignified life. If it includes the right of dignified life, which includes the right to choose a partner for marriage or choose a friend or a freedom of expression, whatever we want to express, need not only be in writing, expression can be, my lord, in love or other forms. And that it is now settled that it is innate. It is not an acquired, my lord, thing. Call it queer, call it what you like. If the rights have to be identical, then I must get the recognition of my union the same way as the recognition of the union of two others. And since it is based on an infraction or an implementation of my fundamental right, I can come to the court and the court need not wait for the legislature. And there is a direct passage, my lord, in one of these judgments, in Charaman. So, my lord, I can't keep waiting. There can't be a mandamus to the legislature. Legislature may or may not do. I cannot force the legislature, neither can the court. By that time, our lives will have gone. And our fundamental rights, my lord, will be in name. That there is 5 judgments of the Supreme Court saying that you have the same rights. Same panoply of rights, passage after passage. If it is the same panoply of rights, there must be a remedy. And the remedy can only be a declaration to that effect by the highest court of the land, saying that this is a fundamental right. And once it is the imprimatur of this court, then, my lord, it must follow that the state is bound to respect it. Then the society will respect it, and the stigma in the workplace or the public place will then go away, and I'll be able to enjoy, my lord, a unit of marriage, a unit of family. Because that is what is accepted in our society. So in short, I need not wait for Parliament to do what it wants to do, because there can be no mandamus. And then your lordships have said repeatedly, if fundamental right is involved, the doors of this court are open to an individual. I have a right to come here. I have a right to complain that this is what is happening to me in real life. You know, it is happening to us in real life. When we go out, when we talk, when we meet people. Slowly, my lord, it is being accepted because the criminality is gone. But not to its full panoply. Because people say, what right have you to get married? Which law? Which court? You got a judgment from the Supreme Court in the first one. Where is the second one? So unless and until, I get a recognition of law under Article 141, because that the other legislative thing is not available to me. Vishakha or whatever. If I have, my lord, a right, that right must be examined by the court, and if found, it must be guaranteed. 32 itself is a part of fundamental rights. It must be guaranteed by the court. How will the court guarantee it? My lord, it's not a case of property that your lordship will take it from him and give it to me. Or some money, my lord, taken from me and give it to him. Your lordships will, my lord, give it by a process which is known to law,
Interpretation.
which is, my lord, interpretation of my fundamental rights, and thereafter interpretation of the law concerned. And then leave it to Parliament that this the court has done. If you want to formalize it in law, as Justice Bhatt put it, if you want to formalize it in law, you jolly well amend the act or bring a new act, as these countries have done. But if you don't, my lord, the law can't remain static. Law moves, society moves, there's evolution. Rights are different, things are different, thoughts are different. Therefore, the court will act when it is called upon to act. It will do whatever it can within, my lord, its judicial parameters.
So in other words, like two alternate lines of approach for the court. Assuming you are right that you're entitled to a declaration.
Yes.
I mean, assuming, of course, we have to hear the other side. Assuming you are right that there should be a declaration of the right to marry, then there are two courses of action according to you. Either the court then finds a legislative void in that Parliament has not legislated expressly to recognize the right of marry. And therefore, finding a legislative void, you supplant that deficiency so long as Parliament enacts law. The other option is to locate the modalities for implementing that declaration in existing law.
Correct. So, my lord, my short, most respectful answer would be, if you take Vishakha as an example, in Vishakha, there was no law at all. The court laid down a set of rules which was to work as interim law, if I may use that phrase, interim law or rules and regulations under Article 141 till, my lord, Parliament acts. Parliament then acted. But the void was filled up in Vishakha in this form. I am saying that in our case, because of our past history, Vishakha had no history. There were no cases before that. We have past history of Puttu Swami, Navtej, all these cases, Shafin, etc., etc. In that past history, all I am requesting is the second step, and the second step to be implemented not by the Vishakha rules, but by virtue of the law already available by, my lord, a process of legislative interpretation. That's how I would put it.
The vacuum which it filled in and the law which came in. Are you canvassing for filling in a vacuum, leaving it to the legislation to do what it wants?
No, my lord, I am not saying that your lordship may give a declaration, then leave it for somebody else. No.
Therefore, I asked that question.
Yes. Because, my lord, life is passing by us by. We can't wait. How long will we wait?
So you're looking at an interpretation of the legislation as it stands that should be expansive. This is what
our model, where your lordship in constitutional adjudication have equalized and brought the left out category into the existing category, my lord. Not just the executive instruction case in Nakara. In All India Sikkim Old Settlers recently, following Vishnudas, Handimal, ITO Lawrence and other cases, where, my lord, some people were left out of certain benefits. Your lordship said striking down will deny everybody the benefit. I will now equalize them, my lord. A good body of case law. The other is the Fowry model, my lord, of South Africa, where they said the common law understanding and the statutory understanding is unconstitutional. We strike it down, but we suspend the declaration. No doubt in South Africa, there's an express provision in 172 permitting that. But, my lord, that was how they equalized it. But your lordships have gone one step further. Read in, my lord. But your lordships have read it in, my lord. Nakara was an executive instruction case, but I have got statutory provisions where your lordships have equalized the left out category. The last of which is, my lord, the judgment 3 months back in All India Sikkim Old Settlers, where the Indian origin settlers who did not give up citizenship, my lord, of India, were left out of the Sikkim register. And our Income Tax Act, my lord, confined benefits to people who are in the Sikkim register. So our argument was, we never gave up the citizenship pre-accession. Lordship said, yes, we will now equalize you.
Different ways where reliefs are molded.
Reliefs are molded.
Prabhakar.
That's the rent control matter.
No. During an interregnum period, the retirement age had been decreased from 58 to 55.
Oh, yes.
This court, by Constitution bench, upheld it. But later, due to public pressure, it was restored.
Yes, yes.
In between, people had retired.
Nagaraj.
And what was restored was with retrospective effect.
Yes.
The court said not giving retrospective effect is resulting in discrimination and gave it retrospective. One of those rare instances where relief is molded in a particular manner, where legislation intends a certain consequence.
Consequence, my lord.
So,
Now,
Vishwanathan,
my lord, in
will it not
Sikkim,
involve
the classic case where your lordship equalized it. So, my lord, that need not, my lord, deter or, my lord, hold back the court at all. If your lordships find that confining the status of marriage to heterosexual couples is wrong, and this is, my lord, a status which requires recognition by the state, denied to a set of people who otherwise have fundamental rights. Your lordships find that, your lordships have already, according to me, now when your lordship said equal platform, words are, my lord, very specifically used. Your lordships will, my lord, say that they have to be recognized and brought into the sphere. It is for Parliament to tailor law to bring it in accord with fundamental rights, my lord. It can never be that, my lord, you await for them to legislate. That will be, my lord, submitting to, my lord, popular will, which, my lord, is completely contrary, anathema to fundamental rights. The whole idea of fundamental rights is to, my lord, to keep it out of the reign of majority.
Now that we have understood, broadly, we've understood the canvas of the matter, then we can really, at least at this stage, we are not ruling it out for the future, we can steer clear of personal law in that case. So if we steer clear of personal law, then perhaps we make the first, I mean, that is one possible option as you opened it up.
As far as